So I'd like to welcome here Professor Imer Flores from National University of Mexico. It's a pleasure to have you here again with us, Professor Imer. And I'd like to ask you, Professor, what is, in your opinion, the general agenda in legal theory? What is being discussed? What is at stake now in legal theory, according to your view?
I think that for some time the debate was clearly the hard-working debate, and at some point the positivists took like the debate into the discussion between inclusive and inclusive positivists. But I think that by now the debate has become broader. Some of the positivists started to engage more with Dworkin on the normative discussion. So for instance, you'll see that even though there was a classic line of argument saying, well, the law, and I will call this the two-system view, the law is one thing, the merit or demerit of law is another thing, that's morality, that's a different story. But now a lot of positivists have been engaging in willing to discuss the law and then the moral part. So it's now very common to hear about normative positivism, ethical positivism, Waldron and Campbell, but you can also think of Liam Murphy, and so doing that part. In addition to the traditional positivist way, like the exclusivists saying, well, this excludes morality, such as Raz, Shapiro, Marmor, Dixon, and so on, or it includes morality, but it's not necessary to laws, like the inclusivist, Walucho, Coleman, Hema. But now you can see that they are discussing. And for instance, Fresh Shower, is saying, well, we have very much into the lines of Benham, we have to discuss first what the law is, the descriptive part, the explanatory part, and then with that in place, we can criticize the law that is in place and change it and put something else. So he was willing to engage into the normative consequences of the decisions or changing the law and so on. So I think that's what I see as the picture that has been going on after this first hard-working, then positivist, inclusive, and exclusive. And now I think we are already in this discussion on the normative dimension, but I would like to emphasize that this somehow I still have framed it in the two-system view, whereas Dworkin in Justice for Hedgehog, he emphasized the view of considering this one system in which law and morality are integrated, that to the extent that law becomes a branch of political morality being a part of morality. So the arguments are all the way tied to the moral dimension, and I think it has some of the authors have, for instance, Marmor has said that farewell to conceptual analysis, suggesting that that's not the best part. We have to move to somewhere else. Scott Hershowitz published an article called "The End of Jurisprudence," suggesting that it's gone, the jurisprudence, the traditional way we have seen it, and clearly indicating that we have to go into a more normative discussion. So that's what I will see. Or what I guess I'm seeing already, and what I expect will be like the next part of the discussion will be emphasizing the two-system versus the one-system view. And at some point, I have the feeling that it is, from my point of view, I'm closer to the Dworkinian position, is the one-system view is right. And I take somehow, at some point, there will be a debate, or let me put it the other way. At this point, I think the debate is now defined in Dworkinian terms, whereas before Dworkin was always like reacting, and now I guess we are in a different position, and somehow I think everyone is engaging in the discussion of morality and normativity, and I think they are trapped in trying to hold the two-system view, and now from the Dworkinian side, I think pushing like the discussion into the one-system view is very promising. That's probably what I think this is the current momentum in jurisprudence.
Let me ask you something more contextualized to Mexico. I mean, Mexico, as much as Brazil, has been very much influenced by the European continental tradition. And how does Mexicans put together these two traditions, and how is the nature of the current debate in legal theory in Mexico?
Well, I will say that, as you said, well, we were clearly very close to the continental tradition, and I won't say that we are close to the Anglo-Saxon tradition by now, but I think what has been like the tendency is to see that those were two extremes, and they were actually not really like the truth really lies somewhere in between. Just to make like the point general is that continental tradition was into legislative law, who is going to, the legislature is going to make the law, and the Anglo-Saxons were into the judicial decisions. And I think by now, Mexico, Colombia, Brazil, Argentina, it's clear that both parts are parts of the sources of the law. Whatever the legislature says is part of the law, and whatever the courts in interpreting the law says the law is also part of the law. So I think we are giving much more role to judicial decisions throughout the region, and I think throughout the world, and I think that's the right way to go. In a more contextual matter of Mexico, what are the current debates in Mexico? I guess I can tell you some of the stories recent past. For instance, gay marriage was held constitutional for all the country, and actually they issue a declaration of incompatibility, a declaration of inconstitutionality, to say that any law, any local state constitution, any law that says or states that marriage is between a one man and a one woman, or that the end of marriage is the procreation or perpetuation of a species, is unconstitutional. By now, it's clear in Mexico that marriage will have to be for same-sex partners, clearly also opposite-sex partners, and it will have to be granted into the idea that what is important, the function of the institution of marriage, is to protect the family, to protect the relationship, to have mutual respect, mutual concern between the two partners, and so on. So I think that's one already settled discussion in Mexico. We have different discussions going on. There is one I think is very interesting because it has broader implications than for Mexico. That is that in Mexico, as you know, we have these problems regarding drug dealing, narcotráfico, and the previous administration issued like declared the war against the drug lords, and this war has been very costly, not only in money, all the money that is spent in security, in armament, in intelligence, and so on, but also has been costly in deaths of people, I guess, clearly criminals, but deaths of criminals, but also of innocent people. So I think like revising the policy is something that we have to do, and the government, now there's a different administration, didn't change the policy completely and remain into this kind of the war on drugs, but they haven't changed the policy. And the legislature, the Congress, the Mexican Congress, has not changed the policy as well. In the meantime, the civil society, academia, legal academia, we have been like emphasizing that there's a need to change the policy, that it is a very stupid way of dealing with the problem. The problem is much more complex, clearly, and so on. And one of the decisions the court had to decide and make the decision was in a case in which 4 petitioners were asking for amparo to get permission to consume drugs, to produce their own drugs and consume their own drugs. And concretely, they were talking about marijuana. And an administrative office, they asked permission to this administrative office. The administrative office say, no, you don't have the permission. And then with that, they were asking for the amparo. And the first chamber of the Mexican Supreme Court, which, let me just brief parenthesis, the Mexican Supreme Court has 2, well, you can sit in a plenary session of the 11 justices, one being the Chief Justice, or you can sit in 2 panels of 5. The Chief Justice doesn't have panel duties. So in the first panel, in the first chamber, they had to decide this amparo. And the way they decided was pretty much the following. It said something like, there's an absolute prohibition on drugs. And there's this policy and the deaths and so on, and then these 4 petitioners come asking for us to grant them the amparo to consume their drugs. And they are arguing that they should have, and according to the different human rights conventions, that they have this kind of right to develop their own personality, their own person, so different freedoms of choice to decide what to consume, what not to consume, to the extent that the court said, well, yeah, they're right, they have these rights. And so a way in which the health law is saying no to drugs in an absolute prohibition way is not engaging in this argument of the people being let alone to make decisions. And for instance, we have alcohol, and we have cigarettes, and we have, so even caffeine, you can make the case that there are somehow addictions or that may cause problems. But because in certain or culture tolerates those, okay, they are allowed. But what about letting these people to consume their own drugs and so on? In this case, marijuana was the way in which they were reaching, like, the sense that, well, they have rights. People have rights. They have the rights to decide what they want to consume, what they don't want to consume. And clearly, an absolute prohibition is canceling them their rights. So the Congress, the current administration, has to reflect upon their policy. So they are granting them pardon for these for persons to outproduce and consume their marijuana for recreational purposes. But what do we can expect of this? We can expect more cases going into the Supreme Court, to the extent that the Supreme Court will be saying 1, 2, 3, 4, 5, and will end up issuing a declaration of inconstitutionality, saying, you know, prohibiting drugs is unconstitutional, so let everyone have drugs. And they are very conscious of saying, no, we have to go and ask the legislature, so the legislature has to find out which drugs to allow, which drugs not to allow, which to forbid, how to regulate them. So instead of just prohibiting in absolute terms, they have to come with a different regulatory scheme regarding drugs. And that, I think, is a nice discussion that has to be open. We have to discuss, well, how the effects of drugs. We need information so we can make have a better understanding of the problem. And for instance, I guess everyone agrees that the use of marijuana for medicinal purposes, someone is having a lot of pain, and the only way to ease the pain will be marijuana, which compared to drugs, which are also very intrusive, will be lower. And so why not? And people tend to agree that that's okay. But if you are willing to accept that part of going into that direction, why not accept recreational use with the regulatory schemes that clearly will say not drugs or no marijuana to children or persons under 18 years, no more than X grams per day, month, week, year, can be sold to this person, so you can keep some sort of control. So I think I think that the decision was really good, because on one hand they were enforcing a legal right, an adjudicative right to say that the people have rights, and on the other hand, it was like sending the message to the legislature that it is on their ground, on their terrain, to make a legislative right, to make that into a regulatory scheme, which it cannot be prohibited in absolute terms, drugs.
Oh, okay, well, thank you very much, Professor Imer. It has been a pleasure to have you here for the second time. I hope to have another opportunity to have you here again and to strengthen the relationship between Fundação Getúlio Vargas and UNAM. Thank you very much.